Well, hello, everybody, and thank you for joining us on this Tuesday afternoon. Today, we're going to do a deeper dive into the Americans with Disabilities Act and what that means for your business. If you've joined us in the past, you know that I am Sophie Dietrich, the HR professional for the Compliance Center here at Wagner, Falconer, and Judd. Our team is here to support your business as you navigate any human resource and employment law questions, and we're really happy to have you with us today. So some quick housekeeping items before we get started. Please send any questions via the chat option at the bottom of your Zoom window. We will have time for questions from the group, so send them our way. And also, so you are aware, this webinar is being recorded to share with those who could not attend live. So with those items covered, let me introduce you to our presenter, Janelle Stanton. As many of you should know by now, Janelle is a senior associate with the employment law team here at Wagner, Falconer, and Judd. She brings over 9 years of employment law and business litigation experience to the table, and she dedicates much of her practice to counseling business leaders such as yourselves on all things HR and employment law. I know she's our favorite thought leader to have around, so we're always excited to have her share with us, especially on this very important topic. So again, thank you everybody for joining, and with that, I'll hand things over to Janelle.
Awesome. Thanks so much, Sophie. And again, just another quick welcome to everybody for joining, and thank you for joining today. I'm very excited for this topic. I know that this is one of the areas that for a lot of employers is very murky. And unfortunately, there is a really good reason why it's murky. Unlike the FMLA, the Family and Medical Leave Act, that has very clear requirements as far as timeframes for requesting leave, timeframes for providing any medical certification, as well as a 12-week cap. The ADA, the Americans with Disabilities Act, does not have any of those things. So this is a murky area, and we're going to talk about some common misconceptions with the ADA. And as a special bonus, we did devise a quiz. Don't worry, we're not grading, and we cannot see what your answer is to any of these questions. So don't be shy about participating. We'll talk about some examples of accommodations, and then we'll wrap up by talking about some of the more difficult accommodation issues. So without further ado, and please have grace for us. We have run this in a few practice sessions, but we've not run this live. So I hope that this works. Like I said, we can't see who says what, so do not have any anxiety about this. So just please, if you would participate, we would be really excited for that. All right, so talking about some common misconceptions, true or false? The ADA does not apply to small companies. So Sophie, if you would put the quiz up. So the first question is, the ADA does not apply to small companies. Is that true or is it false? Give it a few more seconds here to allow people to submit their answers. All right, so Sophie, do you want to go ahead and end the poll? All right, so 1 said true, but 8 said false. All right, and the correct answer is false-ish. I couldn't really say it was necessarily false because I suppose there could be some companies that potentially don't have to comply. But the ADA does apply to companies that have just 15 or more employees. Some employers get tripped up and think that they have to have 50 or even 100 employees in order to have to comply with the ADA, but it's actually 15. The thing to really watch out for is most states have a version of the ADA that applies to much smaller companies. For example, the Minnesota Human Rights Act, which also prohibits discrimination on the basis of disability, applies to companies that have just one or more employee. And a lot of states are similar. Some bump that number up to 4. It just kind of depends. So you do need to sort of keep an eye out if you are even smaller than 15. There might be various state laws that apply to even smaller companies. All right. Well, this is as much fun as I thought it was going to be. So thank you for participating. All right. Common misconception 2. An employee asked for an accommodation, but I just know we can't accommodate the employee, so I can deny their request outright. Is that true or is that false? Sophie? All right. Go ahead and throw your votes up there. Maybe I made this one too easy. All right, we'll give it just a few more seconds to vote. All right, I think you can end the poll now, Sophie. All right, false. You all got this one correct. Amazing job. So employers have to first engage in the interactive process and at least consider the accommodation that's requested, gather any necessary medical documentation, and talk to the employee about other accommodation options that might exist. We're going to do a much deeper dive into this in a little bit, but just again, I just want to really stress the point that an outright denial of an accommodation request without even having a conversation or engaging in any other fact finding or considerations is really a risk. And it's a risk for a ADA discrimination and possibly failure to accommodate lawsuit. All right. Common misconception number 3. True or false? Under the ADA, employers must give people with disabilities special privileges known as accommodations. Sophie? All right, so is that true or false? Under the ADA, employers must give people with disabilities special privileges known as accommodations. Ooh, this one is more contested. All right. Okay, Sophie, you can end the poll. Okay, this was a little bit of a trick question. So 63% of you said true and 38% said false. The correct answer is actually false. These are not special privileges. Reasonable accommodations are intended to ensure that qualified individuals with disabilities have rights in employment that are equal to, not superior to, those of individuals without disabilities. And this is really critically important to keep in mind when you have an employee making a request for an accommodation that other folks without disabilities might also want. Think a remote work agreement or an office space or other types of reduced work schedules, things like that. It is possible that your other employees who do not have disabilities or that have disabilities that don't require the exact same accommodation may be upset or jealous that this employee has an accommodation that is something that they want. But it's not a special privilege. It is a right, just to ensure that they are on equal footing with other employees who do not have disabilities. So a little bit of a trick question there. All right. True or false? Under the ADA, an employer cannot fire an employee who has a disability. Sophie? So under the ADA, an employer cannot fire an employee who has a disability. Is that true or false? Oh, Sophie, you're way ahead of me. Okay, let's see. So, 2 of you said true, 6 of you said false. The correct answer is false. An employer can fire a disabled employee. The issue becomes, it is probably a termination that you want to spend additional time thinking about before you undertake that termination. And that's because if you're terminating a disabled employee, and what I always say this, perception is reality. If the employee has a disability or they've recently requested an accommodation and now they're being terminated, there can, especially considering when it's close in time, there can be this perception that the termination is actually as a result of the employee having a disability or requesting an accommodation. So an employer can certainly fire a disabled employee when the termination is unrelated to the disability. So if there are other performance issues that justify that termination, or there are egregious violations of your company policy, things like that. If the employee does not meet legitimate requirements of the job with or without a reasonable accommodation. So if the employee, no matter what, can just not perform to the standards that your company has set. They cannot meet the production standards established. Employees with disabilities are not required, again, to get special privileges, but they are required to be given accommodations that can allow them to perform at the same level as an employee who is not having the same disability. So if they cannot meet those standards with or without an accommodation, then they may be able to be fired. And a disabled employee can also be fired if the employee poses a direct threat to the health or safety in the workplace. We'll talk a little bit more about that direct threat analysis later on in the webinar. I should also add undue burden. So we'll talk about that as well. But not a disabled employee can be terminated, but again, is a situation that should warrant a little pause. Okay, and next one here, true or false? The ADA interactive process is only required when an employee explicitly requests accommodations. Okay, Sophie, is that true or false? All right, so we've got, let's see, we've got a split again. 38% of you say true, 63% say false. Again, the correct answer here is false. So the falsity is the explicitly request piece. So again, maybe a little bit of a trick question, but an employee does not have to explicitly ask for an accommodation in order to be protected by the ADA and trigger the obligation to participate in the interactive process. So the obligation to engage in that process, first of all, it can apply when a disability is obvious. So maybe an applicant is using a wheelchair and they ask for the job interview to take place in a handicap accessible location, for example. So if the disability is obvious, then you do not need to engage in the interactive process and you provide the accommodation that's required. You also have to engage in the interactive process when an applicant or employee discloses an impairment and requests a modification to how their work is performed. So again, you're not usually, unless they've been talking to a lawyer or unless they are a lawyer or HR rep, the employee is not going to say that hi, I have a disability, I have a substantial impairment to one or more major life activities, and I am needing a reasonable accommodation under the Americans with Disabilities Act. Please let's engage in the interactive process. If that happens, great. That person's talked to a lawyer. So again, handle with kid gloves. But if the applicant or the employee says something like, I've been really having a hard time lately, and I could use some time off. That on its own, it's a little dicey, but that should trigger you to start having this conversation. A lot of times this looks like somebody saying like, hey, I'm going through a divorce right now. I'm really struggling with some depression issues. And, it'd be really great if I could work from home for a little while. Bang, bang, boom. That's it. The employer now has to engage in the interactive process with the employee. So there has to be a communication of a disability, depression in that situation, and a request for a modification to how they do their work, working from home. So, all right. Well, thank you so much for participating in our inaugural quiz. If you guys have enjoyed this, please let us know. We can keep doing these as well. So now I want to talk about, what kind of accommodations need to be provided, and kind of thinking about the overall lens to think about accommodations through is, how can we get creative? What are some outside of the box things that we might be able to do to work with our employees? So I did this through a series. I've got, I think, 4 scenarios that we'll look at, and then think about how we might be able to accommodate these particular employees. So one of the kind of can be difficult to accommodate disabilities is as it relates to depression. Everybody experiences depression in different ways. So for some, depression can be very debilitating, of course, and can impede somebody's ability to get their job done. Other people may suffer from depression, but work is like their one port in the storm. It helps keep them even and balanced, and they love to work and they throw themselves into it. So depression is experienced very differently by different people. So here we're talking about Alex, a dedicated employee who's been working as a software developer in a tech company for the past 5 years. He's always been praised for his exceptional skills and innovative solutions to complex problems. Great, love it. However, over the last few months, his performance has noticeably declined. He's been missing deadlines, making mistakes in coding, struggling to collaborate effectively with team members. Okay, so Alex is having a rough go. Concerned about Alex's declining performance, the supervisor, Carla, decides to have a performance review meeting with Alex. During the meeting, Carla expresses her concerns, informs Alex that if their performance does not improve, they may face disciplinary action, including a written warning. So, right? This happens all the time, declining performance, no necessary reason, no reason why Carla would know what's been going on with Alex. So Alex says, well, actually, I have been struggling with severe depression for some time now. It has impacted my ability to focus and perform at the usual level. And Alex explains they've been receiving treatment and therapy, but it's been challenging. So Carla says, okay, what do we do now? And, this does happen where you start to have a conversation with somebody about their performance and something gets disclosed. And sometimes it can be very, the employees just being vulnerable and honest and has some legitimate concerns, can also be used defensively. And I have seen that in the past. Every time somebody has a performance review, all of a sudden there's some new ailment, which explains the poor performance. But let's assume in this case that Alex is being genuine, and he has now some need for accommodation. So in this situation, there's a number of different things that could be done here. So you could offer and discuss with him a flexible work schedule. So maybe adjusting working hours or working remotely on certain days to accommodate treatment appointments or therapy sessions. You know, it can be very difficult to find therapists in general, but finding a therapist who works within your schedule can be really complicated. So perhaps allowing, you know, Alex to work remotely on Tuesdays, which are the days he sees his therapist. That could be a reasonable accommodation that allows Alex to continue getting those going to therapy and keep working and being a productive member of the team. Or I guess return him to it. Possibly a reduced workload. Maybe the employer can temporarily reduce Alex's workload or reallocate some of the tasks to other team members to alleviate the pressure and stress that Alex is experiencing. Now, again, this is something temporary. Of course, you're not required to overload the rest of your employees to an extent that it's not healthful or even helpful to your other employees. So, but maybe a temporary restructuring or taking away of some non-essential duties to reduce a workload for a temporary solution may help him get over that hump. Providing a quiet workspace where Alex can work without distractions, helping to minimize triggers that might exacerbate depression symptoms. So that, you know, maybe providing an office or moving that employee to a different part of the office can help restore some calm and help, again, fight that depression that he is feeling. Conducting regular check-ins. I will say, I see this a lot. Employers, you know, an employee comes to the employer and they say, hey, I've got you fill in the blank ailment. And so the employer says, yep, great. Okay, go out on leave. Thanks. And then sometimes they don't hear from that employee for months. We have talked to clients who haven't followed back up with employees in years. This is not the best practice. When an employee goes out on ADA leave, there should be regular check-ins, or even if you're approving an accommodation that's not leave, having regular check-ins to see how are you doing? Are you making any progress? Are there any changes or tweaks that we need to make to your accommodations to better support you during this time? So I can't say it enough, like just picking an accommodation, going with it and never checking in is not good practice. So doing regular check-ins, I would do that across the board. And then maybe offering access to an employee assistance program. So if you do have an EAP, suggesting that Alex take advantage of that, I think is also a great accommodation. Okay, migraines. This is another can be tough situation. Sophie, I see you came off mute. Do we have questions?
Yes. Do you want to look at the question now or save it for later?
Fire away.
Yeah, the question is, does an employer have to provide a permanent flexible work schedule if being able to adhere to a full-time schedule is an essential part of the job?
I mean, no, I would say that not necessarily. And that's because most of the time, ADA accommodations are meant to be potentially temporary, but that's not, I mean, it's very hard to come up with absolute yes or absolute no answers in the context of the ADA because it really does depend on the facts of the case. But probably not, but it is possible. So I know that's not a great answer, but this is where doing those check-ins, becomes really important because if a requirement of the job is that they maintain a consistent schedule because that's your operating hours and you need it to be fully staffed during that time, and there is a need for somebody to work different hours. Well, again, accommodating that for a time and then checking in and seeing, hey, how's it going? Is this helping improve things? And if the answer is no, we need to continue on this flexible schedule situation. And, after a time, it is possible that could become an undue hardship for the company to continue to provide. And you may need to look at, well, maybe, part-time hours or other types of accommodations are feasible. But just because an accommodation starts out as reasonable, over time, accommodations can become unreasonable and they may need to be denied. So that's a great question and kind of a good illustration of the needs may change over time, and is again another good plug for doing regular check-ins. Thank you, Sophie. All right. Let's talk about this one, and then if there's more questions, feel free to keep putting them in the chat there. So we have Sarah, who works as a graphic designer in a creative agency. She's very talented, highly valued by her team. However, she's been facing a significant challenge lately. She suffers from chronic migraines, which can be triggered by various factors, including stress, bright lights, and oh boy, prolonged screen time. Totally understand that. I think prolonged screen time is really bad for most people. But despite her best efforts to manage her condition, Sarah finds herself struggling to cope with the demanding workload and the intense pressure of meeting tight deadlines. The migraines often leave her incapacitated, forcing her to take time off work unexpectedly, which not only impacts her productivity, but also creates disruptions within her team. Migraines are a tough one because, again, it is difficult to predict when one's going to come on. They can come on suddenly. They can last 2 or 3 days. They can be gone for 6 months, and then something else can exacerbate that condition. So in exploring some possible accommodations for Sarah, again, looking at a flexible work schedule, might be a good idea to provide so that she can adjust her working hours to accommodate migraine episodes. So that could include starting work later in the day when she feels more rested, or working from home during particularly difficult days if there's a big workload, and she's going to need, some more quiet, or to not have the commute, because, commuting can bring on stress for lots of people, and could potentially trigger a migraine as well. Look at workspace modifications. So maybe giving Sarah a workspace that minimizes migraine triggers like adjustable lighting, glare reducing screens, noise canceling headphones, depending on, whether there's light sensitivity or sound sensitivity associated with those migraines. Allowing Sarah to take short, frequent breaks throughout the day to rest and recharge. That can help if migraines are triggered by prolonged screen time or stress. And then again, maybe offering the option to work remotely. Obviously, in this situation, a graphic designer and a creative agency is probably more conducive to remote work than production or hospitality or other situations. But if the situation does allow, considering those remote work options. Sophie, was there a follow-up question to?
No, that's it. You got it.
Oh, okay. Got it. All right. Okay, vision impairment. So here, Shannon, and I see I have a real penchant for names that start with S. Shannon has been with the company for several years, has consistently delivered outstanding results. However, she's facing a new challenge when she begins experiencing significant vision impairment due to a progressive eye condition. Concerned about her ability to do the job, Shannon decides to disclose her vision impairment to her supervisor, Michael, in hopes of receiving accommodations to continue her work successfully. But Michael expresses doubts about accommodating Shannon's condition, believing that her role heavily relies on computer work and visual tasks that may be difficult for someone with vision impairment. Before Michael goes ahead and says, no way, you have to work on a computer, you need to have good vision, we can't accommodate you, there are some accommodations that could be explored relating to vision impairment. Screen reading software. There is screen reading software that could be installed on Shannon's computer. It can convert text displayed on the screen into speech. Depending on how serious her progressive eye condition becomes, it could potentially convert the text into a Braille output that would enable her to access and navigate digital content. Possibly adjusting font sizes and contrast settings to make text and graphics easier to read. Maybe looking into voice activated technology. There's a software called Dragon that can help folks that have that have the vision impairments, and allow control of the computer and to perform tasks through various voice commands. Braille displays and keyboards. There are Braille displays and Braille keyboards that are actually very cool looking that can, you could equip Shannon's workstation with that, enable her to read and input information using a tactile feedback. And then making documents accessible, ensuring that all digital documents, presentations, materials, everything that Shannon gets, making sure that it is compatible with assistive technologies such as screen readers and Braille displays. Okay, we've got a little bit of a wild card here. So broken bones. We got Jerry. He's a mechanic at a local garage, and he broke his arm playing a competitive game of ultimate frisbee, as one does, over the weekend. Due to his broken arm, he cannot wield a wrench, and therefore he cannot perform the essential functions of his job. Does the garage have an obligation to accommodate Jerry? Is he protected by the ADA in this situation? Well, here, while Jerry does have an impairment, it does not substantially limit a major life activity if it is of limited duration and will have no long-term effect. So if Jerry comes in, says, "Oh man, frisbee, I busted my arm." Eek. Okay, well, there's not a major life activity that's being impacted because presumably it will heal and he will regain the ability to use that broken arm. So when an impairment is of limited duration, it is unlikely that that employee is protected by the ADA such that you have to provide reasonable accommodations. All right. So that just gives you, again, I wanted to give you a sense for the variety of different ways that an employer is expected to potentially accommodate an employee. So there are a lot of resources out there, and I'll talk about them a little bit here, but coming up with an accommodation that can allow the employee to perform the essential functions of their job can become difficult. Most of us are not doctors, and we don't maybe even have a sense for what the person's disability is to even begin to think about how we can provide the accommodation. And we can talk to the employees. That's what the interactive process is. But the employee may also not have any idea what they can do to get their job done. So, couple of things, obviously looking to outside resources. I didn't include this here because we'll talk more about it later, but of course, getting medical certification from the employee's physician is a good way to go. The physician can say, yes, this person has a disability. This is what it is. This is how their ability to do the job is impacted. And here are my suggestions for how to accommodate the employee. That's a start, but a lot of times, I got to be honest, we get those documents back and the doctors kind of just phoned it in and there's no actual useful information in that. We'll talk about how to deal with that situation in a couple of slides, but there are some outside resources if you and your employee are kind of coming up dry with what you can be doing. My favorite one is JAN, the Job Accommodation Network. Their website is absolutely phenomenal. It has an A to Z list of all sorts of different disabilities, many of which I've never even heard of. And it talks about all of the symptoms that can present with that specific disability. And then it can suggest, based on the symptoms that are presenting, accommodations that exist. It's really very slick. I can't recommend it enough. I suppose it's possible that Jan has not thought of all disabilities or all ways to accommodate. So you could loop in a vocational rehabilitation specialist. So perhaps you can refer the employee out to that specialist, or you can retain somebody and pay for that as the employer. Job coaches might also be able to be utilized here. So again, we really need to work on being creative and finding possible ways to provide these accommodations. And I know it's not always obvious, and so it's okay to rely on those resources. You can also reach out to your friendly neighborhood employment attorney as well. Another thing that I like to recommend is trial accommodations. If at first you don't succeed, right, try again. You might try an accommodation that sucks. And so you need to scrap it and move on and try something else. There is no harm in continuing to tinker until you find the right recipe of workplace accommodations and schedule and technology. You might have to kind of Tetris together a very custom solution depending on the employee involved. And like I said, the ADA and the accommodations are fact intensive. So what you provided for one employee with migraines may not work for another employee with migraines. Different things trigger different migraines. Some people get triggered by stress. Some people get triggered by light. You just never know. So trial accommodations are a great way to see what fits, see what works. Reassigning tasks. So reassigning tasks to another team, another employee, taking away marginal tasks completely. Non-essential functions that can be removed that allow the employee to do their essential functions of their job. Reassignment is a great tool. There's also, things to think about. You may hit the point when it becomes an undue hardship. If you're looking and looking and looking and nothing's working and you cannot find a way to get the employee to get into the office or meet the production standards or what have you, maybe that's because the accommodations are proving to cause an undue hardship. Undue hardship doesn't mean, well, this is hard. It's a pretty high bar. It has to be unduly costly, extensive, substantial, or disruptive, or fundamentally alter the nature or operation of the business. So that's a lot, right? You need to look at the cost of the accommodation, of course, but taking into consideration the employer's size, financial resources, the nature and structure of the operation. Some employees request accommodations to be able to have a beverage. I would probably be one of those people. But I've talked to employers where employees are working in chicken houses and are wearing full hazmat gear because yuck, just, yuck. But in that environment, you can't be in full hazmat gear and drinking from your water bottle. So you might not be able to provide all of the accommodations that are requested. And that could also be because of this direct threat situation as well. An employer can require that an individual not pose a direct threat to the health and safety of either themselves, drinking water in a chicken house, or others in the workplace. So a direct threat means a significant risk of substantial harm. Think about somebody who has epilepsy and very severe seizures. That individual driving a forklift in a warehouse where they maybe are the only one working at a particular time of the day, that may pose a direct threat, and there may not be a way that you can accommodate that individual. And again, it can't be a slight increase of risk of harm. It can't be speculative. We see this a lot of times with pregnant employees, where the employer's like, well, you're pregnant, you can't do this thing, you can't lift that ream of paper, you can't work in this environment. And even if it's, from the goodness of your heart, you cannot speculate about whether there's a direct threat to that particular individual. So it has to be based on objective, factual evidence. But if there is a direct threat, is there another way to eliminate or reduce that risk? And possibly there isn't. But again, being creative, thinking really critically, and taking some time having the conversation becomes really important when the accommodation appears to be somewhat elusive.
Hey, Janelle, we've got a question.
Yep.
We've got, isn't reassigning job duties causing an undue hardship for those who are taking on the duties, especially if the company is already understaffed?
Yeah. I mean, so reassignment of job tasks to others may not be reasonable in all situations. If you're, I'm thinking of, like, let's say you're a construction company and you're already having a hard time finding workers that can stick around, and all of a sudden you have an employee who can't lift more than 10 pounds, and there's really just no practical way that you can have that you can't fully relieve that employee from lifting 10 pounds. I mean, there are situations where reassignment would be an undue hardship on the company and would be properly denied. But then you'd have to think about, is there anything else that can be done? So maybe that person works part-time, and then you hire a temp, who can lift 10 pounds. That's, again, not a 100% guaranteed recipe for success, but of course, reassignment may not always be feasible. So let's change our facts of that vision impairment hypothetical that we just talked about. So if we change the facts and we consider that Shannon has been a delivery driver with Niall. So before she was, what was she? She was working in an office. What was Shannon doing? Can't even remember now. I don't know. I wasn't very clear. So anyway, she was working in an office. Let's call it an office. She was working on a computer. I know that. So now she's been a delivery driver with Niall, an e-commerce juggernaut, for several years. She's done a great job, just like she did when she was working in the office. And she's got this progressive eye condition. Well, now Michael says, hey, you drive for a living. There is obviously no way we can accommodate you in this position because it is unsafe. It's a direct threat to put somebody with a severe vision impairment behind the wheel of a delivery truck. And I would say, yes, Michael, that is true. However, because there's always a however, Shannon has past experience working in an office as an administrative assistant. Niall has an open executive assistant position. Shannon says, hey, I want to transfer to that position. I'm qualified. And Michael says, oh, yeah, okay. Well, that is a job transfer is okay. You have the requisite skill and experience for this position. So we're going to go ahead. The point I want to make here is job transfer. It is the accommodation of last resort. The law does not require that a company create a new position for a disabled applicant or employee where one did not exist. And the employee has to be qualified. They have to have the requisite skill and experience to be able to do that job. So if Shannon didn't have this past experience and she didn't have the qualifications necessary, the job transfer could potentially be denied because she's not qualified for that position. So again, Niall here, they might find themselves in the position of not being able to provide any accommodation that works to keep Shannon employed there. All right, another example of a difficult accommodation situation is drug and alcohol addiction. This one is tough, and it's so hard because I know a lot of companies, they want to do the right thing as it relates to the employees, but addiction issues, they are hard to kick. So an employee can relapse and have ongoing struggles with their sobriety. The way that the law is structured here is current illegal drug use is not protected by the ADA. So somebody who is currently using drugs illegally, and this includes prescription drugs if they're using them illegally, getting them on the street versus through a valid prescription, that's not protected. And those individuals can be denied employment or fired on the basis of that use. So you can deny employment or fire somebody for illegal drug use or using drugs illegally. Do be mindful of drug testing laws, especially in Minnesota and Iowa, but really, really be careful in Minnesota. If you recall, employees, if it's their first time testing positive following a drug test, that employee has to be offered the option to go to a rehabilitation program and successfully complete that before you can terminate. Just know that the ADA doesn't necessarily protect that individual, but there are rules about drug testing that you should keep in mind. Now, what is current use? Like if somebody used yesterday, and then tests positive next week for that, I'm thinking specifically in the situation of marijuana, that does become really hairy. And so you want to make sure that you are consulting with counsel if you have one of these situations where an individual is currently struggling with a drug addiction issue. Alcoholism, courts have determined that alcoholism is likely a covered disability, and they are protected then by the ADA if they are an alcoholic or are a recovering alcoholic. But that doesn't mean you have to allow that alcoholic person to use alcohol in the workplace or come to work under the influence. That is never required to be allowed. You also can hold these employees to the same performance standards, just like you do any other disabled employee. There's, I'm thinking of an example here where somebody who is an alcoholic may often be late to work. They may have stayed up too late drinking, they've woken up, now they're hungover, and they're physically unable to perform the responsibilities of their job. In that situation, the employer can take disciplinary action on the basis of poor performance and conduct, but you can't punish them more severely than you would other employees. And if there are accommodations that would help improve that performance, again, I'm thinking about sending, that person to potentially a rehabilitation program or modifying their work schedule so they can attend AA or go to therapy. There are times when you might be able to provide accommodations for somebody who is an alcoholic or recovering alcoholic that would allow them to get the job done. The ADA does not require that the employer provide an alcohol rehabilitation program or to offer rehabilitation in lieu of disciplining that employee if it's alcohol-related misconduct or other performance problems. So you don't have to forgive that misconduct. There's a case that I have seen cited many times in doing research where an employee broke a company's policy prohibiting being under the influence of alcohol in the workplace. In that particular case, the court held he could not belatedly avail himself of the reasonable accommodation provisions of the ADA to escape discipline for his misconduct. That's great language. Unfortunately, though, he broke a bunch of rules and said, well, hey, I'm an alcoholic and I need an accommodation. The court said, I don't think so in this situation. So even if somebody does have a legitimate disability, there, again, might be times when you just cannot accommodate. Okay, I kind of talked about this and foreshadowed it a little bit in the beginning, but very often, and I think any of the lawyers in my office will tell you that we've all looked at it. We've all sent off paperwork to have an employee fill out the medical certification, and it's so vague or it's so incomplete that it's almost useless. But I wanted to talk here, I'll talk about how to deal with that situation, but I did want to stress the importance on the timing of medical examinations or inquiries, because medical examinations or questions about somebody's medical health, medical status, though it is unlawful to ask those types of questions in certain scenarios. And the timing of those examinations or inquiries is really important. So pre-hire, when you're talking to an applicant, it is unlawful to ask an applicant whether they are disabled, about the nature or severity of a disability, or to require the applicant to take a medical exam before making a conditional job offer. So at the pre-hire phase, no. You can say, can you perform the essential functions of this job with or without an accommodation? If they say yes, you move on. If they say no, well, this is where you can start engaging in the interactive process. But pre-hire, you can't do very much at all. Post-offer, but pre-employment is the sweet spot. So you've made an offer of employment conditioned on drug test, background check, but also a medical examination, and they've not begun working for you. In that time frame, after an offer has been made, but before employment begins, employers can ask applicants to take medical examinations or make other inquiries if it is similarly required for all other employees in that job category. So if you have an employee who has potentially a very visible disability, you cannot single them out for medical examination. That would be discriminatory. If you require it for everybody in the job category, then you can do that. Post-employment, once they begin working for your company, you can only require a medical exam or ask about a disability if you can show that the requirements for either are job-related and consistent with business necessity, including when an employee discloses a disability. And this is when we are allowed to start asking for medical certification. If the employee discloses a disability and requests an accommodation, then you can ask for medical certification. However, 2 times when you shouldn't. If the disability and the need for the accommodation are obvious, you cannot ask for documentation. So again, that situation that I talked about at the beginning, where a job applicant is in a wheelchair and they are asking for a handicap accessible place to conduct their interview, you don't need to engage in the interactive process and get the medical certificate. You don't have to do all of that. And in fact, the ADA would take the position that you can't do that. You also cannot ask for documentation in response to a request for an accommodation if the individual has already provided the employer with enough information to substantiate both that the employee has a disability and needs the reasonable accommodation that the employee requested. So there are couple of caveats to this where at times when you can't ask for that. But assuming you can and you get it back and it totally sucks, this happens a lot. So now what? The first thing to do is to try providing additional information about why the first certification is insufficient to the physician via the employee or other medical provider. It doesn't have to be a physician or an MD, other healthcare provider. Give the employee more time to comply. I mean, I don't know how many physicians or medical professionals see, or how many of these types of certifications they see, but I gotta assume some doctors are like, whoa, what's this? This is from outer space. I've never seen anything like this. Because sometimes I get them back and I'm like, this is the least helpful thing I've ever seen. You might just need to provide more information. So maybe this is an email that you send to the employee that says, hey, this certification sucks. And here is the more specific information that I need to be filled out to determine whether you have a disability or whether there is an accommodation that can help you do your job. If you try to reform that medical certification and you're still unsuccessful, the company can choose to send the employee to the healthcare professional of the company's choosing, but the company has to pay for that. So if you want to send them to a vocational rehabilitation expert, or you want to choose a physician that you know will give you the information that you need, that is something that the company does have to pay for. Okay, I've got a couple more. I know we're running out of time. The demanding employee. So the company believes they've found an accommodation that will work. And I know you came off mute, Sophie, but if we could just put a pin in it, I'm just going to rush through these last couple of slides and then get to more questions. But, company thinks you found an accommodation that will work, but the employee wants a different one, the one of their choice. Now what? So, this happens again, sometimes if an employee is demanding an office, but there are other accommodations that would work, or the employee is demanding to work remotely, but there are other accommodations that would work. The employer can choose among reasonable accommodations as long as the accommodation chosen is effective. So if you are saying, no, we cannot accommodate you to work from home, we're going to give you an office space that's private, that's quiet, or we're going to give you a workspace that's away from everybody else, we think that that is going to be effective. And if it is, then that is reasonable. If there are two possible accommodations and one costs more or is more burdensome, the employer does have the ability to choose the less expensive or less burdensome accommodation. Just be careful with this. And again, this might be a situation where you want to loop in counsel, because denying an employee their requested accommodation can lead to hurt feelings. Hurt feelings are what lead to lawsuits. Okay, one more difficult situation is the never-ending leave situation. Just remember that in some certain circumstances, job-protected unpaid leave can be a reasonable accommodation. However, what we're not usually, somebody asks for a week off. Okay, that's easy. But what happens when an employee comes to you and they say they have cancer, and they don't know how long they're going to be gone, or they've just had a stroke, and there's no clue whether that person will ever be able to come back to work? So when you get those types of requests, you need to look at the amount and or length of leave required. So obviously a period of a week, probably not going to lead to an undue hardship, but an open-ended, uncertain request for leave, that can quickly lead to an undue hardship for an employer. What is the frequency of the leave? Do they need every Wednesday off forever, and you need somebody to work 40 hours a week? Well, that might mean that you can approve the leave, but you have to make their schedule now 4/10s. And maybe that's not compliant with what the employee's disability is. So again, another factor to consider. you need to consider whether there's any flexibility about the days on which leave is taken. For example, if Mondays are a really heavy day because of whatever your factors are, and the employee needs Mondays off in perpetuity, maybe that is not a reasonable accommodation anymore. You might also need to look at whether the need for intermittent leave is predictable or unpredictable. Migraines, you never know when they're going to hit. What is the impact that employee's absence is going to have on other coworkers? So a key employee's absence will be felt much more than an employee who can be easily replaced on a temporary basis by somebody from a staffing firm, for example. And then what is the employee's absence? What is that impact on the operation? So unfortunately, there is not a hard and fast amount of ADA leave that's considered reasonable. And courts are all over the place on this. Some courts have said that an accommodation for 6 months is too long to be reasonable. Others have said 6 months is maybe reasonable under the circumstances. So unfortunately, there is no answer. You need to consider the facts of each case. And look, you're never required to just sit there twiddling your thumbs saying, oh my gosh, we cannot meet our deadlines. We cannot fill orders. We cannot do all of these things because X employee is out on leave. If you can hire a temp or temporarily hire somebody, you may need to do that. And remember, this is unpaid leave, so you're not paying this individual. And at some point, you're going to have to put that person on COBRA if they're no longer working for your company, depending on your plan. So maybe you do need to put somebody into that position in a part-time way or for a temporary time. So again, lots of material here. I just never seem to be able to effectively squeeze an ADA presentation into an hour. It's just such a complicated topic. So I will hang out for questions. Have any others come in, Sophie? I believe they have.
Yes, we've got another one. If someone in a wheelchair applies and meets the requirements of the job, but is unable to get up and down the facility because the company is not wheelchair accessible, does that mean the company must make wheelchair accessible space so the potential candidate can get up and down the facility?
Probably. Yeah. That's probably going to be required, but you're going, again, I can't say for sure yes or no, because making some workspaces wheelchair accessible is going to be much more economically feasible than others. If I look at our office as an example, the doors downstairs accessible. There's an elevator. Everything here is flat. However, the bathroom, there's only one floor, the 4th floor, that has a wheelchair accessible bathroom. And our microwaves, if you're going to microwave your lunch, are up high. So we could, with minimal cost, probably install a door opener on the bathroom and move the microwaves into a place that is reachable. But adding ramps or, lifts or elevators could become extremely expensive. So it just depends on the workplace and what kind of modifications need to be made to make your facility wheelchair accessible. So unfortunately, the answer on that one, again, is it depends. But hopefully you're a Compliance Center client and you can reach out and you can talk to any of our smart lawyers or HR professionals, and we can help you make that determination.
Great, thanks, Janelle. And the other comment we got was maybe a tip from one of the attendees of just reminding us to reiterate the points about asking the medical provider for accommodation ideas if the leaders are stumped and how to relate, the incomplete information from the form back to the actual job duties. So that's a good reminder of we can always ask for clarity from the doctors.
You can, but you have to watch out for that. So you can't go and just talk to the physician. So of course, that's the best place to get that information is from the medical provider or other healthcare provider. But you have to communicate unless you get a waiver or an authorization from your employee, that communication gets filtered through your employee. So that's where I said, like, maybe drafting up an email that says, we've considered X, Y, and Z accommodation. It's not working. What else you got? But yes, you can, that the healthcare providers, most of the time, other than your employee, the best source for the accommodation ideas that will actually help. But thank you to whoever submitted that.
Perfect. Thanks, Janelle. That is all of our questions for now. So unless anyone else is furiously typing, we'll wrap up. As always, you can reach out to us directly if you didn't get a chance to ask your question.
All right. Well, thank you so much, everybody. I've got Chris's information thrown up on the screen here. If you want to learn more about the Compliance Center or how Asset HR can help, here's his information. Light him up. All right. Thanks, everybody. Take care.